If you've been asked to sign a joinder, waiver, or consent in a probate case, you might be wondering why. And the reason is that within the probate, since you're in court, there's a whole lot of due process that's required. Beneficiaries are entitled to notice. Creditors are entitled to a time frame to make claims and to respond to objections. And at each step, all these individuals are given the opportunity to agree and consent to the situation. So this may be a consent to the initial petition that's being filed. Does everybody agree that the will is self-proved and should be admitted, and the individual that was nominated should actually act as personal representative? The judge needs to know if there's a conflict or a dispute so that he or she can have a hearing if necessary, or look further into the evidence here. So if you contrast that with the joinder, waiver, and consent, that's an agreement that the individual is going along with whatever that petition or that motion happens to be. So let's say there's a petition to determine homestead and all the interested parties have agreed to that, then the judge is going to be more likely to sign that order determining homestead more quickly and easily. So that's kind of the benefit that you're looking at. But there's also an opportunity to object, and there's time frames for doing so. And sometimes it does make sense if you're not comfortable with the particular request, or if you just want more information, then not signing that waiver may be a way to preserve some rights. It may, preserve an opportunity to file that objection, and that can be a helpful thing. It might also kind of slow things down a little bit, so you have to look into that, or increase costs perhaps. So if you've gotten a joinder, waiver, and consent, or if you're in a probate and your interested parties aren't signing those and you have some questions about it, feel free to reach out and we'll see if we can help.